Oracle has a long history of being sued by its customers, and the past few years are no exception. What does that litigation landscape look like? That's what I want to talk about today. My name is Marcus Harris. I'm a software and technology attorney. For the past 20 years, I've drafted and negotiated a variety of technology-related contracts and litigated failed software disputes in courts across the country. In April of this year, 2025, Veronica's auto insurance sued Oracle and NetSuite for what it claims is a failed implementation. The lawsuit alleged that Oracle and NetSuite fraudulently induced Veronica's insurance into purchasing the software, and those promises of functionality and performance were ultimately untrue. Veronica's auto insurance brought claims of breach of contract, breach of something called the implied covenant of good faith and fair dealing, fraudulent and negligent misrepresentation, as well as other statutory claims. And the fact section of their complaint really lays a familiar scenario. Oracle and NetSuite apparently assured Veronica's auto insurance that the system would be tailored to the insurance industry, which is the industry that they were in, that it would not require third-party add-ons, and that it would be implemented in a full Spanish version, and none of those representations came to fruition. And so Veronica's brought suit, and that suit is still moving forward. In 2024, a company called RealScape Group filed a class action against Oracle, essentially asserting that Oracle made wide-ranging misrepresentations to a variety of its customers, that the software was essentially out of the box, off the shelf, easily configurable software that was easy to implement. And the allegation in that case really is that it is untrue, and in fact the software is more complicated than represented. The implementations are going to take longer than Oracle lets on. They're going to cost more, and the amount of money that you're going to put into those and the time that it's going to take is really going to be much longer and more expensive than Oracle represents. In another lawsuit from 2023 filed in the Northern District of California, River Supply brought suit against Oracle, asserting that Oracle had represented that the NetSuite software was a ready-to-go solution that could go live within months, basically at a fixed price. And again, none of those representations turned out to be true. In a case from 2020, Janko Foods brought a suit against Oracle, alleging breach of contract and fraudulent inducement, claiming Oracle had misrepresented both its capabilities and the system's readiness for the food distribution industry. In 2021, Advanced Lifts Inc. Sued Oracle, claiming that Oracle sold it functionality that did not yet exist. So essentially, Oracle sold it vaporware. And then in a lawsuit filed in 2021, Morse Communications sued Oracle, claiming that the software was misrepresented, that the services were not provided in accordance with the contract, that Oracle had made negligent misrepresentations and fraudulently induced it to enter into the contract. And in 2020, in a suit brought by my office, we represented LK in a lawsuit against Oracle and NetSuite, claiming that the software was misrepresented. The functionality was not what it was presented to be by Oracle during the sales cycle, that the services that were provided in connection with the implementation and integration of that software was not provided in accordance with the contractual obligations that NetSuite and Oracle had, or the warranty obligations that they had in that contract. That case was ultimately settled out of court. And I think, as you look at this litigation landscape, you look at the litigation profile, there's a couple of major themes here. And one really is that, Oracle is being sued over and over again for misrepresenting the capabilities of its software. One, in a class action, which is a pretty serious scenario, and then individually by multiple customers. And the claims are all they kind of mirror each other. And I think there's no it's not by accident. I think that Oracle is well known for incenting its sales representatives via commission They're well known for exaggerating the capabilities of the software. And I think there are many times when they take it too far, and I think these lawsuits are really an indication of that. One of the interesting nuances in one of these cases is that Oracle has been accused of essentially unfair business practices. And what that allegation is really stemming from, and I think this is another lesson learned from these lawsuits, is that you really need to take a look at what you're signing before you sign it. And I know that's a very base thing to say, but the amount of clients that I have that don't look at their contracts with any level of substantive review and analysis is pretty shocking. And in this particular case, the plaintiff accused Oracle of really giving it what would essentially be an estimate or an order form, which was maybe 1 or 2 pages long, that detailed the software that they were purchasing, but it incorporated by reference, if you want to call it that, various hyperlinks that would point to Oracle's website where were apparently located the contract that would govern their relationship. But the problem with that is that the hyperlink wasn't particularly set off. It wasn't identified as being a hyperlink, according to the allegations in the complaint. And when you clicked on the hyperlink, it took you to a general page, and you had no understanding, according to the plaintiff, which contract was actually applicable to that transaction. And so there's a big dispute about what terms are governing that relationship, where that lawsuit can be brought, if it can be removed to another court per the contract that supposedly governs that relationship. So I think as you move forward with Oracle, you really need to be careful. You really need to look carefully and critically at what they're telling you. If they're making representations about functionality, features of the software, you want to get those in writing. You want to try to incorporate them into the contract to the extent you can. I think you're going to get a lot of pushback from Oracle on that, but I think it's imperative that you try to do that. If there's something that is mission critical, it should be addressed in the contract, mission critical functionality. And then I think you've got to have an understanding of what you're signing. I think if you are forwarded some simple agreement that looks like it's one page via DocuSign, that should be a red flag. These agreements are almost never that simple. I think if you've got some one pager in front of you, you've got to start asking questions. You've got to make sure you understand what you're signing. And I think by doing that, you really set yourself up for success. You give yourself a dog in the fight if something goes sideways. If you found this information useful, please feel free to reach out to us at taflaw.com.